Valid, void, voidable. Do you actually know the difference? Most real estate students think they do until they see a question about it pop up on the exam, and all the definitions start to blur together, triggering that stomach-dropping test day dread. Mixing up the vocabulary can cost you on questions you actually know the answer to. So if you're studying for the real estate exam, keep watching, because by the end of this video, you'll know the difference between void and voidable so well, you could take my place and teach it to someone else. At the very least, you'll be able to answer the rapid fire round of questions coming up at the end of this video without any dread. I'm Janice Robles, an instructor at Freedom Tour Realty School. And I'm going to break down some contract questions for you the same way we do it on the practice tests in our courses, which have helped thousands of students pass the real estate exam on their first try. Let me throw a question at you right away. Tom and Jerry sign a written agreement. Jerry will pay $2,000 a month to rent Tom's basement apartment. The contract is best described as A, valid, B, voidable, C, void, D, unenforceable. And the correct answer is A, valid. A valid contract is fully legally binding because it contains all four contract essentials. Both parties accepted clear terms. Something of value is being exchanged. The agreement is legal, so far as we can tell from what's provided in the question. And both parties entered into it freely and knowingly. When all of that checks out, you have a valid contract that a court will uphold. Question 2. Shaggy and Fred agree in writing that Shaggy will purchase Fred's vacation house. The next week, Shaggy discovers that the sale is illegal under a local ordinance restricting property transfers in the area. This contract is best described as A, valid, B, voidable, C, void, D, unenforceable. The correct answer? C, void. A void contract has no legal standing whatsoever because it's missing one or more of those four contract essentials we talked about in the last question. In this case, it's missing a legal object. The agreement has to be legal to be valid. You can't make an agreement to do something illegal together, like rob a jewelry store, and expect the courts to consider that a valid contract. It doesn't matter that both parties agree and signed in good faith. If the deal itself can't legally happen, the contract is immediately void. So you can think of valid and void as two ends of the spectrum. You either have a legally binding contract or you don't. Pretty straightforward. Let's look at another question. Wiley and Rode shake hands and verbally agree that Rode will purchase Wiley's desert property. They don't put anything in writing. This contract is best described as A, valid, B, voidable, C, void, D, unenforceable. The correct answer is D, unenforceable. An unenforceable contract qualifies as a valid contract, but there's something about it that makes it unable to be enforced. It's right in the word itself. When we're dealing with real estate contracts specifically, the tip-off that a contract is unenforceable often has to do with whether or not it's written. Because of a legal doctrine called the statute of frauds, certain types of contracts, among them real estate contracts, have to be in writing in order to be legally enforceable. But there are also other reasons a valid contract can be unenforceable by a court. For example, a contract is unenforceable if something happens that makes it physically impossible for the agreement to be carried out. Let's say the house you agreed to buy burns down, or you wait so long to enforce a contract that the statute of limitations passes and it's no longer enforceable. A contract can even be unenforceable if it's so ridiculously unfair to one party that a judge just looks at it and says, I'm not going to enforce this, even though it technically fulfills all the contract essentials and is a valid contract. But the biggie to watch out for in real estate is definitely whether or not the contract is in writing. Question 4. The landlord told Barney that the apartment he wanted to rent was in a quiet residential neighborhood. After signing the lease, Barney discovered the building was directly next to an office building construction site the landlord knew about. This contract is best described as A. Valid, B. Voidable, C. Void, D. Unenforceable. As you might have already guessed, the best answer for the test is B. Voidable. But why? A voidable contract can be canceled or voided by a court, but hasn't been canceled just yet. Notice the suffix, able. Voidable literally means able to be voided. The same way fixable means something is able to be fixed. But a fixable problem doesn't mean it's been fixed yet. It just can be. Same thing here. A voidable contract still exists as a valid contract, but one of the parties can go to a court and request that the court void the contract if they choose to. Unless and until that happens, the contract remains valid. So what makes a contract voidable? And why is Barney's contract potentially voidable? Usually it comes down to one party not having fully and freely consented to the agreement. Whether that's because they were unable to actually consent to the agreement, were misled, were pressured, or were flat out lied to. The law gives the disadvantaged party an out, so long as the court agrees with them. And it's up to them whether they want to proceed with the contract or attempt to walk away. Okay, are you ready for hard mode? For her 17th birthday, Tweety received a large check from her grandmother to help cover a security deposit on an apartment near her college. She found a studio she loved. The only drawback was that it was not pet-friendly and Tweety hoped to eventually get a kitten. She kept that to herself for the time being and signed an 8-month lease. This contract is best described as A. Valid, B. Voidable, C. Void, D. Unenforceable. At first glance, there's no illegal deal, no verbal-only agreement, no landlord lying through their teeth. Tweety wasn't under the influence when she signed. It looks like it could be a perfectly normal lease. And this question has lots of irrelevant extra details that can distract you if you're not careful. The birthday money, the kitten, the lease length, none of that matters. But when you look past the noise, you'll spot the one detail that does. Tweety is 17. She's a minor. And a contract signed by a minor is often voidable. So the best answer is B, voidable. Tweety is able to cancel the contract if she chooses to. But wait, if a court hasn't canceled it yet, wouldn't that make Tweety's contract technically valid? That's the trap this question is setting. Like we mentioned earlier, a voidable contract is considered legally binding and valid, with the ability to be voided. But the question is asking for the best answer. Voidable, in this case, is more precise because it tells you something important about the contract's legal weakness. One party has the power to cancel it. Valid alone doesn't capture that detail. So on questions like this, always look for the answer that's most complete and specific to the situation, not just technically true. And that's void versus voidable, de-dreadified. Which brings us to our rapid fire round. Now that we've successfully de-dreadified contract statuses, see how many you can get right without pausing the video. Pick the best answer. Number 1, a buyer signs a purchase agreement after the seller falsely claims the roof was recently replaced. Voidable. Misrepresentation affects reality of consent. Number 2, a buyer and seller agree on a price over the phone, and the seller takes the property off the market based on the verbal agreement. Unenforceable. Real estate contracts must be in writing under the statute of frauds. Number 3, a 20-year-old signs a 1-year lease and both parties fulfill their obligations. Valid. All 4 contract essentials are present. Number 4, a homeowner signs a listing agreement while heavily intoxicated. Voidable. Intoxication affects confidence and reality of consent. Number 5, a 16-year-old signs a buyer's agency agreement. Voidable, because one of the parties is a minor. Number 6, a tenant signs a lease, but the property is completely destroyed by a flood before the tenant even moves in. Unenforceable. Performance has become impossible. How'd you do? Let us know in the comments. Also, let us know which other tricky real estate concepts fill you with dread, and you just might see them de-dreadified next. Check out our trail guide to the real estate exam for extra practice and study help.